All right, good morning, everyone. Welcome to the Standing Committee on Public Accounts for February 18th. As with every meeting, we start by reading off our mandate and our statement of purpose and values of the committee. So for the mandate, the Standing Committee on Public Accounts is charged with matters concerning the public accounts of the province, the annual report of the Auditor General, and fiscal management. Our statement of purpose and values, the Standing Committee on Public Accounts is dedicated to improving public administration in partnership with the Auditor General. The committee examines the administration of government policy, not the merits of it. The committee strives to achieve consensus in its decisions whenever possible. Members take a nonpartisan approach to the work of the committee. So I'll call our meeting to order. I guess I already began it, and I wanted to welcome everybody. Thanks for being here. And we are having maintenance enforcement joining us today, Department of Justice and Public Safety. So I will call for an adoption of the agenda. Someone move it. I've got Gord. And we will jump right in. So joining us today, as I said, is Department of Justice and Public Safety. We have Sherry Gillis, she's the Acting Deputy Minister, and Clare Henderson, Director of Family Law and Court Services. So welcome and thank you for joining us today. And we will let you begin.
Great. Thank you to the committee for inviting us here today. I am Sherry Gillis. I'm the Acting Deputy Minister, as mentioned, of the Department of Justice and Public Safety. To my right is Clare Henderson. She is the Director of Family Law and Court Services with the department. And that is the division of our department that oversees the maintenance enforcement program. I wanted to start today just giving a bit of a background to the basics associated with the maintenance enforcement program as related to the work of the Assembly in the Maintenance Enforcement Act. So the Maintenance Enforcement Act does set up a Director of Maintenance Enforcement who is an employee of the Department of Justice and Public Safety and is charged with overseeing the maintenance enforcement program. And so it's the duty of the Director of Maintenance Enforcement to enforce maintenance orders, which you would have seen reference to that through the Auditor General's documents. These maintenance orders are filed in the office of the Director, and the Director may, for the purpose, commence proceedings to take enforcement in relation to those orders and to help to collect payments in relation to those. Although the term is called a maintenance order, it can also be an order of the court, or it can be an agreement that parties come to together, parents, and file that with the office. So it can be either of those things. And the minister can appoint certain enforcement officers to assist the Director of Maintenance Enforcement with those tasks. And Clare is the director that is in charge of the program, which has, of course, the Director of Maintenance Enforcement and other enforcement officers associated with it. And her office has been responding over the years to the work in the Auditor General's report. And although I'm sure Clare will speak to it herself, certainly the work of the Auditor General on this file and with the office has been very professional. We've had a great professional relationship working with them on this file, and hopefully you'll see some of those results today.
Thank you.
Again, my name is Clare Henderson. I'm the Director of Family Law and Court Services in the Department of Justice and Public Safety. I'm really happy to be here today to talk to you about all of the work that we have done over the past number of years in implementing the recommendations of the Auditor General. I know that perhaps there may be a public perception that the scrutiny of the Auditor General is something that is not necessarily always enjoyed, but we've really taken this as a positive opportunity to make some necessary changes that we hadn't had the opportunity to consider in advance of the work of the Auditor General. We have worked in consultation with the auditor, particularly during the report back period that they're doing on the value for money audits. One of the biggest changes that we've made in response to the Auditor General's recommendations is our program developed the first public-facing policy manual for the maintenance enforcement program in the country. One of the things that policy manual attempts to address is sometimes there can be a misunderstanding within the public about the role of the maintenance enforcement program. One of the things that's important for the committee to understand and for the public to understand is that the maintenance enforcement program is a neutral order or agreement-based program that doesn't represent one party or the other to an order or agreement, but acts to maximize the collection and disbursement of support under that order. The entirety of our program is focused on making sure the maximum number of families enrolled in the program get the maximum amount of support that we can collect under that program, under that order. One of the things that can be challenging is that some of the people that are enrolled in the maintenance enforcement program fundamentally disagree with the order of the court that requires them to pay their support. Sometimes both of the parties may disagree with the order of the court. For example, the person who's receiving the support may feel that they're entitled to receive more support than what the judge decided. The person who's paying the support on that same order may feel that they were ordered to pay too much support based on what they can pay. And in each and every instance, it's not the role of our program to determine whether or not the order of the court was correct. Our authority is confined within the four corners of that order. And so the step of having a public-facing policy manual was to ensure there was an opportunity for both the public and the staff to understand how and when the discretion of the Director of Maintenance Enforcement is exercised. And that was a very consultative process that we did with staff. And as with any first-time implementation of policy, we spent the next number of months reviewing that policy. And we've just actually posted our first comprehensive update to the policy manual. One of the other things, if you look at the status of our implementation of the recommendations, and I understand that, when one looks at a kind of 51%, if you look at it from the perspective of what my father would have said if I had come home with a 51% on an exam, he would not have been happy. But I can tell you that the 51% of our recommendations that we've put in was a significant amount of work. And we are limited in terms of our ability to get to 100% by our case management software. And so the maintenance enforcement program uses a computer program called MEPS to manage the cases that are enrolled in the program. That platform, I don't want to use the word antiquated because it's from the 90s, and using that word in relation to the 90s makes me feel old. But it is what I would call a legacy software, and it doesn't do all of the things that we need it to do to be able to comply with the recommendations of the Auditor General. For example, the Maintenance Enforcement Program software is not a traditional accounting platform. And not only that, it's not integrated with the Oracle software that the Finance Department uses. So that means when we want to do something like a bank reconciliation, we have to get reports from 6 different areas in order to compile that reconciliation. It's an extremely labor-intensive, manual process that can be extremely challenging to get the information out of correctly. And so, as a result of the opportunity provided by the Auditor General's report, we are in the process of replacing that software. We've leveraged an existing contract that we have in the division, and we are in process of implementing a complete brand new software package that is a financial accounting platform that will integrate a number of the controls that the Auditor General recommended that we have. Which, to be clear, our program desperately wants. We agree with the recommendations of the Auditor General, but unfortunately, with the 90s software platform that I have, we cannot implement those recommendations because we would have to completely change and upgrade that software at significant cost. And because we have leveraged an existing software contract, we are replacing the entire software at a significantly decreased cost than it would be to go out and re-update the Maintenance Enforcement Program software. We call the Maintenance Enforcement Program software MEPS, which can be somewhat confusing when I also refer to the program as MEP, so I apologize. So we are in process of implementing that software now. We are hopeful to have that upgrade complete by the end of 2020. I say hopeful because this is a complete software change, and that process can be extremely labor intensive. Not only because the actual development process is labor intensive, but we then also have the opportunity to do data entry in areas that we don't presently. And so it will have more reporting capability, it will have more control capability. We are exceedingly excited about the ability to implement this new software. I anticipate that once that software is implemented, we will be at basically a 91% complete recommendation status. We had hoped, I can also advise, we had hoped that we had achieved an additional recommendation over the past year. We made a number of changes to process to address some of the recommendations that the Auditor General recommended. And when we were reporting back to the auditor, we reflected that we were complete on another recommendation, and that is the recommendation that relates to the oversight by the Director of Enforcement decisions. In our excitement in implementing that recommendation, unfortunately, and this falls upon, I'll take this squarely on the chin, I neglected to, in my discussions with the manager and the director, to develop a form so that the oversight would be confirmed in the file. And so that recommendation in practice is happening, but from the auditor perspective, because we didn't put a form in the file confirming that it was happening, they couldn't go back in and confirm that that was happening from an audit perspective. Mm-hmm. Because the auditor wants documentation so that they can look at the file and know it's happening. That was an oversight on our part. We were so busy doing the oversight that we forgot to document it. So I can tell you that as soon as the auditor told us that, a form was developed and now that's being documented. And so again, once the new software is in place, we anticipate that we will be at 91% and that we will be very near 100% compliance with the recommendations of the Auditor General. We really appreciated the kind of collaborative discussion that we had with the AG staff that came down. We've been very fortunate. We've had the same auditors coming to the office for the past number of years, and so our program can be extremely complicated for reasons that I'm sure when you start asking me specific questions will become clear. And so it's been very helpful that the AG has been allocating the same staff to come down because they become familiar with the kind of complexities of the office, and it's a somewhat enjoyable experience because it also allows us to test the policies that we're putting in place. We meet with staff. The director has a weekly staff meeting where they talk about complex files and things and make recommendations about, well, this is maybe one of the things that we should change. I think we could be doing this in a different way. And so it's been a really challenging but positive ultimate experience having the opportunity to respond to the recommendations.
Great, thank you. Is there anything else you want to add, or are you okay with us moving into questions?
Absolutely.
Okay, I'll go with Gord.
Oh, this is great. Just first of all, I want to just do a recognition of guests. I'm excited to have Jay Nogler here in the gallery. He's a District 14 constituent, so welcome, and thank you for the work that you do with this file.
I should also point out that Jay Nogler is the manager of family justice programs. He actually was also a maintenance enforcement officer himself, our interjurisdictional support officer, and is one of the driving forces behind the implementation of the policy manual and working with the director in the department. He has been a huge asset to the department, and I'm very grateful for the work that he does every single day.
Right, yes.
And to add on to what Claire is saying, we're very thankful for all of the staff associated with the file. They've put a lot of work into it. And when you're constantly kind of looking at the work you do and trying to make it better, it's important to have insight and collaboration, and hopefully this file has said that.
Every single response that we are complete on, and even some of the responses that we're not complete on, represent thousands of hours of work by our staff. Like, please do not underestimate the commitment and the work that has been put forward by the frontline staff that are not only dealing day to day with clients, but also working to improve the program that they're working for.
Yeah, awesome. Yeah, and I think we see with your passion, and thank you for your passion. And no, this committee is excited to have you here. And I think all of Prince Edward Island needs to understand the work that goes on behind it, and the important role that you play in representing both sides of a very difficult situation. The new software that you mentioned. And it's great to hear that you're replacing and to see your excitement with it. How is that new software going to help you with case turnaround speed times, or does that allow you to move faster?
So one of the things that impacts our speed time with case response is not actually the software. It's the timing upon which parties respond to provide necessary information to enroll in the program. And so from time to time, there can be delays because, for example, someone who wishes to enroll an order in the program, we have a enrollment form that needs to be complete. But if they don't complete that form correctly, or if they drop it off and don't have the opportunity to sit down with staff, there can be necessary information that's missing. The new software will improve, absolutely everything to do with the function of the program. So one of the things that we're excited about, which may not excite everybody, is that the new software will allow us to upload the order or agreement directly into the software, which may sound like a little thing, but from a processing perspective, if the enforcement officer has to go and get the physical file from the file room, that's time, right, to go and locate the file, to bring it back. The new software will allow us to upload the order that the enforcement officer can then enter the information from the order into the software. We anticipate the software will then send an approval to the Director of Maintenance Enforcement, because under the Maintenance Enforcement Act, the Director of Maintenance Enforcement holds discretion as to what, if any part of an order is considered enforceable under the Act. So just a sidebar for a second to talk about what that means. So through our program, we can't, for example, facilitate direct payments to third parties. And so if somebody agrees in a separation agreement or in an order that, for example, if I had a son who was in the Honnold Hockey Association, Association, perhaps the order would say that my ex-spouse would have to pay the hockey association directly. We can't do that through our program, because we can't, from a auditing perspective, we can't facilitate payments to multiple parties and then confirm that they were received. And so that order, that provision of the order, would not be considered enforceable through our program. Now, important point, that doesn't mean that my ex-spouse is not legally obligated to comply with that order. It just means that the maintenance enforcement program can't enforce that particular provision, okay? So when we enroll an order in the program, it has to be reviewed for eligibility. What the new software will allow us to do is have the enforcement officer enter the order in, upload the order, and then send that order to confirm through the Director of Maintenance Enforcement the enforceability of it. Even better, again, things that make me excited, it will allow us to restrict the enforcement of things that are not approved under that order. So it would mean, for example, if my order said that my eligible expenses were hockey registration, gymnastics registration, and equipment for those two sports, if I was to try to submit an expense for horseback riding, which is not included under my order, the program would have a restriction to prevent the processing of that receipt, right? Again, controls, which we are very excited about.
Yeah.
Gord?
Well, that's a good answer. And I'm glad to see that you're going to be able to get some new software and update that. When you're looking at your program, your clients, and I know large majority of the clients understand the court orders and the rulings, and you are the enforcement piece. What happens in the case, and how much of your clientele steps outside of that boundary, doesn't pay, doesn't, those type of things? Like, what would be the percentage of your clients that you struggle with?
So I can tell you that presently we have, as of this morning, 1,732 files in the program. Of those files, 300 of them account for 80% of our arrears.
Could you repeat that for me? So
Absolutely. So that we have 1,732 files in the program effective this morning. Right now, effective February 10th, 10.4 million in arrears to beneficiaries on the files. Of that amount, 300 files represent $8 million of those arrears. And if you don't mind, I'm going to take a moment to talk to you guys about how that number does not necessarily, unfortunately, tell the story that sometimes people think it does. One of the challenges with the maintenance enforcement program is that it's not like a business where if you're in the black, if you're in the red by $8 million, that tells a particular story about how your business is being managed. The maintenance enforcement program is what I will call a living, breathing program that changes every minute that we are sitting here. Because the maintenance enforcement program handles files that move throughout the country nationally. We have everyday courts that are ordering people into the program. And when people come into the maintenance enforcement program, it is possible, to give you an example, so if my spouse and I separate, and it's a year under the Divorce Act, under various circumstances, because with the law there's always, maybe there's a different situation, but let's say you have to wait a year before you can get your divorce judgment. If we don't go to court to get an interim order, it can be 12 months between the time that my spouse and I separate, and if I had care of the children, and before I get an order saying what my child support amount is. And if my ex-spouse didn't pay me anything during that time, that means when the judge issues the order for my support, my ex-spouse, prior to even an order existing, is in arrears of their child support obligation. So orders coming into the program can put arrears on our ledger, which isn't an indication that we haven't done any enforcement action. We can also have people who choose to opt out of the maintenance enforcement program. Under the legislation, every support order or agreement in Prince Edward Island is supposed to be enrolled in the maintenance enforcement program unless people choose not to be involved, because people can agree and they can facilitate their payments and not necessarily need our involvement. But if, 6, 12, 2 years down the road, their relationship breaks down and they wish to have the assistance at that point of the Maintenance Enforcement Office, they may indicate that there are arrears under that order. We also have, in what can be exceedingly complex, something called interjurisdictional support orders. So there are 3 types of arrears to beneficiaries in our program. There are arrears where both parties live on PEI. That means the person paying the support lives in PEI, and the person receiving the support lives in PEI. We can also have an interjurisdictional support order. We have 2 types of those. The first one is we call ISO in. An ISO in file is where the person who's paying the support lives in PEI, but the person who's receiving the support lives in another province. So if I lived in Alberta and my ex-spouse who pays me child support lives here, that would be considered an ISO in file. If I have a support order and my ex-spouse who pays me support lives in Alberta and I live here, that's called an ISO out file. So the in and out is where the person who is paying, or what we call the payor, resides. So if you think about it, if we have two people that live in Alberta, and sometimes people who live in Alberta are very fortunate and they can make quite a bit of money working in, out west, as they call it. If somebody lives out west and they're making 6 figures a year, and then they lose their job, and while they were living out west under the jurisdiction of the Alberta Maintenance Enforcement Program, they were not paying their support. And they can have over $100,000 in arrears on these files. If they move back to PEI, those arrears come with them. That $100,000 in arrears is transferred onto our ledger. And that means if we have 10 people move from out of province with over $100,000 of arrears, which is not unheard of in our program, our arrears ledger goes up by $1 million. And so there are a number of competing reasons that mean that number goes up and down and can change drastically, and is not necessarily a reflection on the work that has been done by the Maintenance Enforcement Program. On top of that, an important thing to remember is that the obligation to pay support is with the person who is under the order to pay that support. We have a number of files where we have maximized the enforcement that we can do at law. We have a number of tools in our tool belt to try and collect money from people who owe support. But if they don't have legal sources from which we can collect that support that's owed, there's nothing that we can do to facilitate the collection and disbursement of that support. Because all of our tools are available if there is money in a bank account, if there is a tax return that is coming in, if there's a EI payment that's coming in. We have legal sources of trying to get that money. But we also have a number of individuals who go out of their way to not have legal sources. We have people who refuse to file their tax returns. We, under the Maintenance Enforcement Act, the Director of Maintenance Enforcement can bring somebody to court and ask a judge to put them in jail. And that may not, unfortunately, incentivize that person to make payments against their arrears. And so one of the things that we have to discuss with the public is that enrollment in maintenance enforcement, unfortunately, is not a guarantee of collection. It is a free service that is provided by government to provide resources to attempt to maximize the collection and disbursement of support.
Gord?
Great answer. And yeah, I was going to ask you, these numbers are pretty staggering. Are we at the time where we have to do more? You talked about enforcement, you talked about, what's the next, in your opinion, what would be the next level of taking this that we can collect more money for those who need it?
So we are constantly engaging in review of both our legislation and how the program functions. I can tell you that PEI is an amazing place because one of the things that we do here that they do nowhere else in the country is that we provide something called the Child Support Guidelines Office. And that is a free service that is provided by government that allows individuals who wish to establish or vary child support, right, to go to court. We provide information and assistance to help people who need to go to court to change or vary child support. Because one of the things that adds to the staggering numbers that we have, for example, is we have people who have a support order that they got say 10 years ago when they were working out west. And support is accruing under that order because once it's enrolled in our program, we keep a monthly ledger of the support that's owed. But that individual may have moved home from out west or may have had a change of circumstance, and they may in fact be on income support. But their order is based on the income that they were making that was 6 figures. And so that order is not technically accurate because they're no longer making the 6 figures, and their child support payable should be based on the income that they have. But from time to time, if that person does not go to court and get that order changed, again, we are a neutral, order-based program. And so we can't just say, oh, well, so-and-so's on income support, so we're just going to change that on the ledger, because that's changing a court order. We can refer that person to the Child Support Guidelines Office, and that person can make an application to the court asking them to not only change that support order, but also do something that we call extinguishing the arrears. And so they can say, you've been accruing arrears in the maintenance enforcement program for 10 years at an amount that wasn't accurate, and I'm going to forgive those arrears. And with that court order, we can reduce the amount on their ledger. So we provide that service for free. We have amazing staff in that program. I can tell you that to date, this year alone, they've helped 244 people, 244 applications go to court to change or establish child support. We also, through some great work in our office, now have a free income tax clinic that we put off in consultation with the volunteer income tax clinic that CRA does. And so every single time the Director of Maintenance Enforcement holds a default docket, we have a beautiful volunteer who comes down from CRA who is literally sitting in an office at the Family Law Center or at the courthouse in Summerside, so that when the judge says, you, sir, need to go and do your tax returns, or you, ma'am, need to go and do your tax returns so that we can calculate your support, which is a win for maintenance enforcement, because what happens when they file their tax returns, ladies and gentlemen? If they get a refund, we have an interception in place, and we can take that money and put it against their arrears. And so that service is available for free because of the great work done through the Volunteer Income Tax Clinic by CRA, which was the idea of a staff person in our office, right? Like, this is the innovation that's happening in the maintenance enforcement program.
Great.
We are also working to put in place a credit reporting contract so that if you don't pay your child support, the Director of Maintenance Enforcement can put a hit on your credit bureau. Now, we'd hoped to have that in place, but let me tell you, wow, is that complicated. That contract to facilitate that credit reporting thing, like, lawyer, wow, it's complicated. Like, they send people, they have to send people to do a site assessment. Like, it is, we will get it. I'm hoping we will get it before 2020, but this credit reporting is people's personal financial information, right? The credit reporting service needs to ensure that we are who we say we are, because we will have potential access to make significant changes to people's credit score, right? So they have to do their due diligence with us, and we're grateful for that because we want to make sure that people's privacy is protected. So, and we do have a number of other things that we're discussing about opportunities for adding to the toolkit that maintenance enforcement has.
That's great. That's great.
And to Claire's point, this is one of the areas where it is the intersection of all 3 branches of government potentially working together. As you indicated, there's the legislative branch that oversees the legislation, and Claire Schott may bring forward from time to time amendments to Maintenance Enforcement Act. There's the executive branch, Operations Administration running the program, and then there's the judiciary, who Claire's workers are in contact with when there are updates or new matters coming forward, so that they understand and are then potentially trying to be more responsive as well to ensure that things run better.
Gord?
No, I just wanted to say too, and doing some research on your program, your stuff online was really helpful. Your questions or your FAQs and your payee and payer and that information. So yeah, great job.
And we're actually in the process of updating that as well to ensure that it's plain language. One of the most important things that we find is that a little bit of communication goes a long way, right? If people understand coming in what their obligations are and what the realities of our program are, everybody's happy.
Yeah, great.
And so one of the things that we've done, for example, is we've notified the bar in Prince Edward Island, the legal bar, that any lawyer who's working on a custody agreement that involves child support or a draft order, they can send those to us in advance. They can send them to the Director of Maintenance Enforcement. And so that we can flag them to potential issues of enforceability. And we love to do that. That's 5 minutes that saves us 3 weeks in the long run, right? Because if somebody gets a court order or an agreement that we can't enforce, then we have to refer them to the Child Support Guidelines Office to attempt to clarify that order, right? Whereas if we can have a discussion beforehand, we can save everybody time, and as we all know, time is money, right?
Yeah, definitely. Perfect.
Great, that's good. Carla?
Would you say, thank you, Chair, would you say that you have enough officers in place in the program to enforce all of those different things?
We've been very fortunate. We last year we were allocated an additional enforcement officer position. We also, through some changes that we've had in staffing, have reprofiled existing resources to increase the number of enforcement officers that we have. We have had some transition in staffing over the past 18 months, and so I don't know that we would turn down the opportunity for an enforcement officer, but one of the realities will be, once we put the new software in place, that will see a decrease in operational demand as well. There's a lot of stuff that happens manually presently that won't have to be manual in the future, and so I am not going to suggest that it may not be the case that there's not a request going forward, but given that it's public funds and we would like to be cognizant of the fact that it's public funds, I think that a prudent thing to do would be to do a review after we have the new software in place, because I can guarantee you that if there is need in the division, that there will be a discussion with the department about whether or not there is an opportunity to allocate additional resources.
Thank you. Carla?
And so in the Auditor General's report, she mentioned that, don't quote me on this, but I think she said only one officer had access to the vehicle registration and the health card database and all of that. Is that something now that all officers have access to?
So the access to that database, so when there's an opportunity to potentially suspend somebody's license, right? There are, first off, legislative thresholds that impact our ability to make that request. Those requests actually come in from the enforcement officers in writing. So under the Maintenance Enforcement Act, the director has the opportunity to make information demands to any public body. If we are attempting to track down what we call a non-compliant payor, we have a great deal of authority under the legislation to send requests for information. And so we have fairly standard form letters that go out on a regular basis to social development and housing, to probation, to Access PEI, right? Asking for information. It's the registration database is not the only tool in the tool belt. That's a recognition for the fact that access to that should be limited in terms of the right to access people's confidential private information. And so when we have a situation where an enforcement officer wishes to suspend a license, that's actually done by way of correspondence.
Carla?
And another thing that she had mentioned and also had been recently in the media is kind of the idea of the inconsistencies between officers, that some officers are viewed kind of more tough than others. Is that something that would have been addressed in your new policy, or is that kind of like, I'm just trying to get a feel for what that means?
Right. So one of the things that's important to remember is that the individual the parties to the enforcement order are not entitled to information about the other party. And so it can be challenging in terms of perception because there are limitations about the information that we can provide from one party to another. And it's important to remember that the discretion of the maintenance enforcement program is a statutory discretion. And one of the reasons why the policy manual was to be put in place, and one of the reasons why the policy manual was just updated, is to ensure that the public understands some of the factors that go into the decision to exercise that discretion. But one of the things that can be challenging is that, so every decision that's made in the maintenance enforcement program is guided by the principle that we want to maximize the support that's available under the program. And so when somebody looks at all of the tools that we have, it may be that for some files, every single one of those tools is in place at the same time. We may have a federal interception on a file. We may have a passport revocation. We may have a license suspension. But the maintenance enforcement officer is in contact with both parties. And sometimes, to give you an example, we will contact a payor who will say, I just got a job. They can provide confirmation that they have a job. And they may have arrears on the file. We may then, in confirmation that they now are going to have a job, we have something called a payment order that can be put in place, which means your employer takes money off your paycheck and pays it directly to us. So generally, as soon as we find out that somebody who is not paying their child support is employed, we're contacting their employer and we're putting a payment order in place. But somebody may say, well, how come you haven't suspended her license? How come you haven't done that? And the enforcement officer may know, well, I know where he's working, which I'm not allowed to tell you. And if I suspend his license or her license, they can't get to work, which means they're not going to get paid, which means we're not going to collect support. And so while I understand that it can be frustrating from a public perception that, well, I know my friend's spouse has a driver's license suspension and I know he paid his amount and, that, why aren't you doing that? We have information that we're not permitted to share, again, because we have to balance the protection of people's personal information as well, right? And so we are very cognizant that this can be extremely challenging. This is about child support, this is about spousal support. But again, as a neutral order-based program, our focus is on taking the steps that maximize the collection and disbursement of support.
Sounds like struggles of a school counselor too, in terms of the confidentiality piece of people kind of trying to understand that, so I get that. Can you explain the rationale for providing a 30-day grace period for the payment of child support?
Absolutely, and I'm actually really happy to talk about that. So first, that 30 days, we consider that to be when you are subject to enforcement. So we talked earlier about our arrears balance and the fact that our program is neutral and order-based. We have to take steps to ensure that we are maximizing enforcement for the maximum number of families in the program. And I can tell you that every single maintenance enforcement program or its equivalent in the country has that 30-day subject to enforcement standard. And that has to be the case. Practically, we cannot initiate enforcement on every single file in the program if the payment is a day late. And that is because, first, there is somewhat of a misconception that if we initiated enforcement on the 2nd of the month, that the money would be there on the 3rd. First, our most successful enforcement tool is something called a payment order. That's the one we talked about earlier, where if you're employed, we take money off your paycheck, right? So the way that works is we would not be in a position to take all of that money, right? And so even if we put a payment order in place, people get paid bi-weekly. And so it would not be a guarantee of a full payment on the 1st of the month. But not only that, We have files in the program where people have not seen any support in years or months. And we have to focus on those files because it is often the case that the full amount of support is paid within that 30-day period. And so unfortunately, we have to look at maximizing the benefit of the service for all families in the program. And it is not practical for us to engage in enforcement when certain families, and I acknowledge the challenge that that creates. We acknowledge that having uncertainty as to when the money is coming in is a challenge for families. But we have to look at maximizing the benefit for all of the families that are engaged in the program, right?
Carla?
This may be out of the scope, and if it is, just let me know. I'm often guilty of that. I'm just wondering, are payers currently charged any fees, like late fees or enforcement fees or whatever that is?
So under the Maintenance Enforcement Act and its regulations, there is something called a deterrent fee. And so if after the 30-day period, someone does not pay the full amount of support that they're ordered to pay or have agreed to pay through the program, there's an automatic $25 deterrent fee that's put in place. Now, that deterrent fee is subject to the discretion of the Maintenance Enforcement Office. So, for example, based on what was a really awesome discussion with enforcement staff, we actually are now seeing some of the enforcement officers leveraging the payment of that fee to incentivize people to pay. And so if somebody who has a great number of deterrent fees contacts the office and says, well, you know, if I pay 6 months of full support payment, can we talk about that fee? We're talking about the fee because that fee is a government fee. That does not go to the beneficiary, it does not go to the payor, that goes to the government. And so where the director under the legislation has the ability to exercise discretion to waive that fee. And I don't think that we take a position on waiving that fee if it means that somebody's going to pay their support and follow through on the payment of that support. And so, yes, long answer to your short question, we have a fee.
And,
Carla?
sorry, Chair, does that, okay, yeah, no, that's good.
So I can also tell you that one of the things that the director is cognizant of is that we don't want that fee to become crushing to the payor because that fee can very quickly add up, and what can happen and has happened is, and ultimately the fee ends up being waived, is that if that fee is so high, we don't want people to think, well, I'm just not going to bother to pay because I can never pay that off. I should also point out, that fee is the last thing that we collect. So if somebody owes arrears in child support and we do a federal interception and take their tax return money, if they owe $5,000 in arrears and $2,000 in fees to the director and their tax return is $5,000, $5,000 goes to their arrears and nothing would go towards that fee. The priority for the program is the collection and disbursement of support to children and families. So that fee is not the priority of the program in terms of collection.
Carla?
It's good to hear because I can imagine that would be stifling because, you know, it's not like the people who are paying child support aren't usually swimming in buckets of money, you know, so that's good to hear. Could you walk us through the process of what happens when someone comes in with a complaint saying that the payment is late, or that, you know, as you had mentioned, their ex-spouse is out west and now their pay has gone up significantly and they're not getting enough child support? I'm wondering kind of what the process for that is, if there's, you know, and how long that usually takes.
So if somebody comes in and raises a concern that the person who's paying the child support has something that we call a change in circumstance. So they've gotten a new job, they're making more money, the amount of support that they get is not sufficient towards what they're supposed to be paying under the federal child support guidelines. That is where oftentimes our really awesome child support guidelines program comes in. We would refer that person to the child support guidelines office because, again, as a neutral order-based program, we cannot change the amount that we're collecting under that order. Even if we are given information that there's been a change, we are not a court, we're not a tribunal, we cannot make evidence-based decisions, right? We neither disagree, agree, or have any position on orders other than the enforceability of that order under the program. So it's a little bit of a complicated question because there is a process that happens in court to have those orders changed and varied. One of the benefits about living in PEI is that we are a smaller jurisdiction and our court is excellent at prioritizing these applications. We have a dedicated time that the court has for orders through the Child Support Guidelines Office. Right? And so, you know, we're talking a matter of like weeks and months rather than a matter of years. But ultimately, the timing of if and when an order changes based on an application, that is with the judicial branch and not our program. So, I don't know if that answers your question.
Yes, yeah.
Carla?
Is there, if anyone else has questions, I can.
Do you want to ask Rob? And then we can come back to Carla. So
Just whenever.
we'll go to Rob and then come back.
Okay, just to kind of clarify a few of the comments. You'd mentioned that there were some computer software issues that were limiting your ability to get to, say, 100% compliant. You'd made a statement that even if you had that, you'd really be about 91% compliant. Mm-hmm. So I'm just trying to get my head around, so why wouldn't you be at, where's that 9%? Because if I'm doing a little bit of quick math, at 732 maintenance files, you got 156 that would be still non-compliant. So could you maybe clarify that?
No, I meant compliant with the recommendations of the Auditor General.
Oh, okay. Mm-hmm. So but you'd be 100% compliant with the maintenance enforcement of all those files then, with the new computer software update?
So to be clear, all of the files that are enrolled in the program are compliant with the Maintenance Enforcement Act.
Oh, okay.
So each of the files that are enrolled in the program are assigned to an enforcement officer who has obligations under the Enforcement Act and through their employment to take action to enforce support. Mm-hmm. So in terms of compliance, it's the recommendations with the Auditor General.
Oh,
so
okay.
we have implemented 51% of the recommendations of the Auditor General. Once we implement the new computer software, we will be at 91%. I'm hoping to be at 100.
Which is the one that's not going to be?
All stuff you'd think I would have written down before I came, and yes.
Well, actually, you know what we can do? Once everybody's asked some questions, maybe we'll go back through each of the recommendations
sure.
and you can give an update and we can read them out and you'll know where we are.
For sure.
So, sorry, Rob, go ahead.
Okay, so just to give you a little more clarity again, so you said 1,732 files are out there. So is a file that's just between a payer and a receiver? That doesn't count how many children are involved with a particular file. So I'm just trying to get a sense, how many children would be involved on 1,732 files?
I don't know that with our existing program I could quantify that for you.
Okay.
And just to tell you why it's a little bit complicated. So we can have one payor who has multiple children with multiple individuals. And so one payor could have 5 files in the maintenance enforcement program. Mm-hmm. They could have multiple children with each of those files. And some of those files have something that we refer to as a global order. So that means that when the judge issued the order, the judge set a set amount of support based on the number of children at the time. And so I'm not certain, I can go back and ask the program if we can quantify that. I'm not certain that the system necessarily, through its reporting, allows me to get a report that tells you how many children are in the program. We do track for each order the number of children, because in order to be eligible to collect support, there's certain rules around when when a child is eligible for support if a judge has not, so an order can have something called a terminating event. So if I turn 18,
Yeah.
which was some years ago, and I choose not to enroll in a full-time education institute, I may not be eligible for continued child support under the order. Again, as with most of the law, it's a little bit complicated because it depends on what the specific order says and the specific circumstances. And for example, we notify people before a potential terminating event so that theoretically they could go to the Child Support Guidelines Office and ask a judge to issue an order saying that support should continue. Right? So I guess the answer to your question is I'm not sure, but I can try and find out.
Rob?
But would you not, I mean, when you say the number of $10.4 million, it would be kind of helpful to kind of understand how many children that is impacting, because that's a significant amount of money.
So just to clarify though, this program does not just deal with child support. We also deal with spousal support.
Okay,
and so
so
that number would be a combination of
Right.
support that's owed under the program. Because when there is a marital breakdown at law, a judge can actually order something called spousal support. And people who receive spousal support may not have children also, or they may have an order that entitles them to spousal support and child support.
Yeah.
So,
Rob?
Okay, well, that's helpful, because yes, I guess one shouldn't assume that it's all child support involved in that. But the one thing I do get as an MLA sometimes is that usually it's the female, but it will come to see me regarding their issues around social services. So usually social services calculates their child support or spousal payments in what they might be entitled to through social services if the person, doesn't have any other sources of income. And so my understanding is that, so is there any social services will count that, and if you don't get that money through maintenance enforcement, that social service does not back it up, right? As those months in arrears accrue. So is there much communication between social services and maintenance support to either verify that amount and or enforce strongly or take more effort to recoup that money?
So just to clarify, under the previous government, there was a change in policy at what is now Social Development and Housing. And it's my understanding, and again, not my area, but it's my understanding that income support no longer considers child support in their...
It doesn't, okay.
in the amounts calculated for income support. So under the Maintenance Enforcement Act, there is a provision that allows individuals to enter into something called an assignment of benefits. And so previously, there were agreements that were entered into by recipients of income support payments where income support, and this is a little bit complicated. So previously, your entitlement to income support, unlike the rest of it, right? So previously, your entitlement to income support was calculated based on all of the income that you received, including child support. And so if income support calculated the child support that you were receiving, your income support entitlement would go down.
Right.
So what they would do is they would enter into this assignment of benefits where I would agree that I would sign over my child support, any child support that's collected, and I would receive the maximum income support available for my program, under the program. And then the Minister of Social Development and Housing, Family and Human Services as it was then, would take action to try and collect the arrears. We had a dedicated enforcement officer through the income support program, but after the change in policy, I can advise that the Child Support Guidelines Office was advised that if individuals who had made an assignment of benefits owed arrears to the Social Development and Housing through an assignment of benefits, that they are no longer taking a position on the court setting aside those arrears. So the long answer to your short question is yes, we actually communicate quite regularly with Social Development and Housing, but mainly to get information to try and locate and enforce against payors. We also spend time talking to payors who are on income support who may have had a change in circumstances, like we addressed earlier, about our income tax clinic and our program to try and have a more accurate reflection of the arrears.
Rob, that's
I'm
it?
good.
Okay. Carla, did you have any more questions? No? Corey, do you have a question?
Go ahead.
I'll go ahead. All right. What I'd like to do is I would like to jump back and go through each of the recommendations one by one, if the committee's okay with that. And you do have a copy with you. So the first one is recommendation 2.29. The Maintenance Enforcement Office should develop and document policies and procedures to guide enforcement officers in administering and enforcing court orders and agreements. That one is marked complete. Okay.
Yes.
And from what I can see, that was complete right away. So that, I'm happy to see that. So thank you. So the next one is 2.34. The Maintenance Enforcement Office should support key decisions in the case files with appropriate documentation. So can you give us a status on that one, just as a refresher? I think you did touch on it in your presentation, but
So this is the one where we're actioning it, but we weren't properly documenting it. And so this is happening, but now we've included a form that we understand the Auditor General will be happy with
okay.
when she comes back.
And when I go back to I'm going to touch on the 2017 AG report, because the 2017 AG report actually had the management responses from 2016 printed in it. So that's why I'm going to go to the 2017 AG report. And you had identified 2.34 as being implemented, correct?
Yes.
So is that what the discrepancy between the two is you were doing it, I guess, verbally, but not actually documenting as it had been indicated, and so that's why the Auditor General then last year identified that you weren't compliant with it?
Yes.
Okay. And so now it's actually a checklist document that identifies, okay.
Yes, and I should also point out that that is one of the things that will also be addressed through the new software. Mm-hmm. That type of documentation will actually happen in the computer file as well. Yeah. One of the challenges that we had with hitting complete on that file, on that recommendation, is that unfortunately the way the MEP software is designed, we can't get a report that satisfies. Mm-hmm. So even if some of the documentation is happening in the MEP system, we can't communicate it out because 90s.
So I just wanted to, just the wording around what the Auditor General will be happy with. It just seems to me that that's efficient. So if so let's say Corey was an enforcement officer and so was I, and I handed I had to take vacation and Corey was going to take over my file, then Corey wouldn't have to read through all the file to see what decisions or try to find that information, right? So to have that document on top of the file to be able to quickly go, okay, that makes sense, would seem efficient that anybody, even if you had a new employee, a new enforcement officer come on board, then there wouldn't have to be a lot of research into each case file to identify it. So I'm happy to hear that that checklist is present now, and so, okay. 2.35 is another one that you have completed. So the Maintenance Enforcement Office should obtain documented consent from beneficiaries when arrear balance is reduced and no longer enforced. So that's complete. 2.38 is also implemented. The Maintenance Enforcement Office should perform and document an independent review of ledger adjustments. That's great. 2.42 is one that is not implemented, and that is the Maintenance Enforcement Office should implement a risk-based quality control review process on case files. So again, I'm just going to reference the 2017 report in which the management response that you had provided to the AG at that time had identified that this was implemented, but in the follow-up, the 3-year follow-up, the AG has identified that it's not implemented. Can you walk me through the difference there?
And again, this is a documentation issue. So we engage in ongoing review of files, and the issue was that the ability of us to provide the confirmation information as a result of challenges with the MEP system, we had to develop we thought that would be the information that was available would meet the standard. In our discussions with the AG's office, we've also developed a physical form to put in the files until such time as the software is in place.
Okay, so this is one that you would identify will be complete with the implementation of the software?
Yes.
Which you had stated, I believe, at the end of 2020 is the ETA for that?
Fingers crossed, yes, that's our expectation. But again, I do need to point out that our rollout of the new software, we have to have the software developed. They're in the process of customizing it for our program. We then have to data enter all of the information that's not presently tracked in the old system. So we can do a data transfer from the MEP system into the new program, but there's a lot of information that the legacy software just doesn't track that we want. And so that is going to require some allocation of like data entry resources. And so there will be a little bit of a lag time. We're hoping that the software development is complete by the end of 2020.
Okay. So, any questions on that from any committee members? No? 2.47, the Maintenance Enforcement Office should define and obtain the necessary reports for effective management and oversight of the Maintenance Enforcement Program. So that, again, I just got my pages out of order. That's 2.47. So this one is incomplete. So can you just quickly summarize? Is that IT as well?
That's an IT issue. And so we do a great deal of management and oversight of the program. I don't want there to be a suggestion that our incomplete on this does not mean that we're not effectively managing the program. It's just, once again, the software that we use does not allow us to generate a number of the reports that both the Auditor General and we want, unfortunately.
Okay. So the next one then is 2.58. This one is complete. The Maintenance Enforcement Office should determine the appropriate distribution of the unassigned balance in the trust account. And then finally, 2.59, the Maintenance Enforcement Office should develop and implement internal controls to safeguard assets and maintain complete and accurate financial records. This is a minimum. This, at a minimum, should include bank reconciliations, periodic review of unallocated amounts in the trust account, appropriate segregation of duties, and review and approval of significant adjustments to client ledgers. So that one is not complete. So can you just give us an update on that one as well?
So I would be remiss if I did not take this opportunity to thank the Department of Finance and their allocation of resources to the Maintenance Enforcement Program to assist us in doing this work. This recommendation, like the other ones, is very much our software challenges. So as I indicated earlier, in order to do the bank reconciliation that's required for the Maintenance Enforcement Program, it is 6 separate reports from 3 different areas that we have to reconcile presently. Finance has allocated resources to us to assist with this, and when the new software is in place, it will be a little bit life-changing for the program because the new software is financial in nature. We are also working with ITSS and the Controller's Office to set the software up in such a way that Oracle reports back into it, which may seem a little bit like a small thing, but is huge in terms of our ability to reconcile, because the way the software works right now is, just say Claire owes support money, and I pay that support money. I actually pay that support money through my online banking or any of the opportunities that we have set up to facilitate payment. That payment actually goes to the Maintenance Enforcement bank account. We then have to transfer that to the controller, who then has the payor on the file as a vendor, and the controller's office pays the money that we pay to them. That's through Oracle. Oracle does not communicate back to us into the program that money was actually transferred. We have to get a report from finance to confirm that the payment went, and so you can see it is a little bit challenging. And we are working so that the new software platform will have a report back, and that will allow us to do the necessary and what we want in terms of the financial oversight. So that will very quickly turn to a check mark when we get the new software.
Okay.
And for the record, ITSS is our information technology service internal to government, which is under the Department of Finance.
Oh, sorry.
Yeah, no, sorry.
And so I understand every department has an allocated number of hours per year that they can use for ITSS projects. Is ITSS currently working actively on this, or is that waiting on your software that is a third party to be updated?
So we have an IT consultant with
Yeah.
Justice,
Okay.
who I don't want to name because she's excellent and I'm afraid people will steal her. And she is actively involved. We also have a project manager from
Okay.
the project management office assigned to the project. Like, this has been very much High School Musical in terms of we're all in this together. And like finance, IT, the contractor, the maintenance enforcement program, like, it is very much a collaborative charge to improve.
Okay. And the case management software, so when was the work on that started?
So the case management software that we are using we're actually leveraging the CompuTrust contract from the Public Trustee Office. And so the Public Trustee Office had a software platform that needed to be updated. And when I was involved in that, because that office also falls under my division, and in the meetings with that contractor, there's a lot of there's some similarities between the work that the Public Trustee Office does as a trust money, right? Like, they're holding money that belongs to other people and then potentially transferring it out. And so working on that, we identified that software would actually function quite well for the maintenance enforcement program. And because we had an existing contract with them, we were able to leverage it at a significantly reduced cost than procuring a whole new software platform. And so the focus, they were mid redevelopment of the CompuTrust platform for the Public Trustee Office. The work on the MEPS, what we call MEPS CompuTrust, started probably about 6 months ago. Maybe actually 12. But it's in earnest right now. So we've got the project manager from the project management office with information technology and shared services and finance. And so it's been quite a bit of change, leveraging through 2 different programs. And so
Was the deficiency in the software programming flagged at the time that the Auditor General completed her recommendations?
no, and you'll note that nowhere in the Auditor General's report flags that the software is a challenge.
Right.
This was based on our internal review and our attempting to respond to the work of the Auditor General. We appreciate the opportunity to engage in the in-depth review, because basically what happened was, when we were working to implement the recommendations, that was when it was identified that, 1994 was a while ago, and unfortunately the functioning of the program has not evolved with the needs of the program.
And some of the recommendations, as you know, they talk of ledger adjustments and other types of financial information solutions. So to that point, it kind of, I guess, eventually dovetailed into that type of a solution.
So when was it flagged that the software had to be updated, or new software had to be implemented? What year?
Probably in 2018.
Okay. So 2 years. So am I right in thinking it took 2 years to identify that the AG items that were still outstanding could be completed only if there was software updated? So what took the 2 years? Like, what was the analysis that was completed in those 2 years to identify that that was your only option?
So the reality of implementing the recommendations of the Auditor General's report, as I said, is thousands of hours of work that went in from both staff and management to identify. I understand that it can appear that when you're looking at a 2-line paragraph, that may necessarily be an easy fix.
Right.
But, you know, there was a significant amount of work that needed to be undertaken, and this provided an opportunity for us to undertake that work. And so I can't sit here and say that this has been an easy process. I can't sit here and say that it's been a quick process. But I used to work in Nunavut, and one of the judges in that jurisdiction used to say quite frequently, we rush at our peril and repent at our leisure. We are very much taking the opportunity to do this quickly. Sorry, no. Correctly.
Thoroughly.
Carefully.
Thoroughly. Yes. Okay.
And so, you know, we made a number of attempts to try and address these issues, and we identified that, it took some time to identify that we were not going to be able to update the maintenance enforcement program software in and of itself. We made a number of attempts to make changes to that software, and because obviously the ideal would be to use what we've got. It is a huge undertaking to create an entire case management software, and as I have said a number of times during this process, I don't want the new software platform to be a platform that people identify with hushed tones as something that was a mistake. We wanted to do it in a way that was financially viable and financially responsible. And so taking the time to identify an existing contract that we could leverage, so that we're talking not millions of dollars to update the platform, it did take some time. And I'm proud of the work that my staff and that finance staff and that ITSS have done to identify how we can do this right.
Great. And to Claire's point, in terms of the response, I think the first iteration of the policy manual was 2018. And then again, some other solutions come out of when they were trying to action certain of those items when consulting to bring that together. And then also it has now had an update even now throughout these other ongoing changes. So the work is, it's continuing now, and hopefully will continue into the future.
Okay, thank you for that. So, yeah. So when you said you'd implement I guess there's 3 IT items here, and then you'd be at 91%. Is the other one 2.34? Is that the one that you...
So we anticipate that now that we have the documented kind of checklist in the files, we anticipate that, you know, when the Auditor General comes back, we would consider those complete now, because we're now documenting the work that's happening, we believe, to the satisfaction of the Auditor General. And so once the software solution is in place, and it increases our ability to report on information and include controls and engage in the financial platform in a financial platform way, we anticipate that we'll be near 100% in terms of our implementation of the recommendations.
Okay. Corey, you have a question?
Yeah, I was just...
You do?
So just looking at the numbers, there was 10.9 million in arrears in 2015 with about 1,960 cases. And currently you said there's about 10.4 million in arrears with about 1,732 cases. So it's dropped by about 200 cases, but the amount in arrears is only dropped by about 500,000. So actually, if you kind of look at it, the amount in arrears has actually kind of gone up. I'm just wondering if...
But again, the arrears don't necessarily tell a story, right? Because if we have individuals who move from other jurisdictions with large arrears balances, or files coming into the program with large arrears balances, the arrears balance, unfortunately, is not, something that we necessarily have a great deal of control over. And so with people moving throughout the country and from province to province, we inherit arrears from other programs, and we also lose arrears to other programs. And so unfortunately, what the arrears balance was in 2015 isn't indicative of any type of action either by our program or through our program. or the fact that without the actions being taken by our program on a daily basis, those arrears balances may be even higher, right? Like we take action on a daily basis. We intercept funds from the federal government. We garnish bank accounts. We suspend driver's licenses. We take a great deal of action to collect and disperse support. We implement payment orders and take money off of people's paychecks, right? And so, again, the thing that can be difficult to reconcile is the fact that the arrears balance, it does not tell necessarily a story about the program or the files necessarily within the program. And again, I point out that of those 1,700 files presently, 300 of those represent $8 million worth of those arrears. And some of those 300 files are individuals who are on income support who 10 years ago had an order when they were making 6 figures in salary. That order, it's their obligation, it's the parties to that order that are obligated to go to court. And I can tell you it causes some frustration for our program because we can contact the individuals with the order and say, would you like, we can facilitate an appointment with the Child Support Guidelines Office and we can get that order, you can ask to have that order changed. We have a free income tax clinic. You can come in and do your tax returns and then go to court and try to have your order reflect the information. But if they don't participate in the process, we have no authority to change that order. We have no authority to remove the order from our program without the consent of the beneficiary, which may not be forthcoming. If we contact the beneficiary on the file and they don't respond, we can't take action to remove the file from the program, even if we've had no response from anybody involved in the program, right? And so, again, while I understand the numbers are staggering, the numbers don't necessarily tell the story.
Corey?
You had mentioned a number of times about people from out west. Do you know how much of a percentage that makes up of?
I do.
Arrears?
I can tell you that of the orders in the program, as of February 10th, $2.8 million in arrears were for ISO in files. That's the file where the payor on the order lives in PEI. Got it. Quicker than me. It took me forever. I had to draw a map in my mind and figure out. Jay used to make fun of me. I think he still does. ISO out arrears are $3.8 million. And the arrears where both parties live in PEI were $3.8 million.
And it's the 2.8 that is, you're saying it's difficult to.
So one of the things that I didn't mention is that for the ISO out files, where the payor does not reside in PEI, we cannot do any enforcement on those files. Because they live in another province, they're within the jurisdiction of that province or territory's maintenance enforcement program.
So that was the 3.8.
That's the 3.8. So that $3.8 million, we are a liaison for the beneficiary who lives on PEI, but we have no authority to make decisions or to exercise discretion about how the reciprocal jurisdiction engages in enforcement. When the individual comes back to PEI, those arrears are transferred to us, and then we exercise discretion over the enforcement of those arrears. That said, we would have had no involvement in the file before it came to PEI. And, as I said, depending on the circumstances, we can only engage with enforcement tools for legal sources of income. And so if somebody comes to PEI with a great deal of arrears and they work in a way that they do not report to CRA, if they work for cash, we have no mechanism available to us to collect that cash. We can garnish bank accounts. We can send a payment order to a payor. We can file your maintenance order against any property that you have so that if you try to sell that property, it has to be paid out before you sell it. We can and do all of those things. But if somebody, and some people go to great lengths to evade paying child support. Some people leave the country. Some people move from province to province. Some people pay cash, like ask to be paid in cash. Some people decline promotions at work because they don't want their child support payments to go up, or their spousal support payments, right? Again, we deal with both types of support. And so that's the breakdown of the arrears as of February 10th. February 18th, these numbers may be different, because at any point, if I'm enrolled in the program and I just say I have $10,000 worth of arrears on my file, and I have a conversation with my ex-spouse and I decide that I don't want to be in maintenance enforcement anymore, I can withdraw from that program, and that those arrears come off our ledger. And that's a decision that the parties to the order or the agreement get to make. And so we, any day of the week, can see any number of reasons why the arrears balance fluctuates and changes.
And to Claire's point on this issue, the provinces sometimes discuss these issues, try to work together, try to get better information sharing practices to ensure that the response times between provinces can be better. But again, it is a provincial jurisdiction model, so every province has their own legislation. But even to that point, the provinces sometimes work together to try to have a uniform law of response to these types of things so that everything will work in concert.
Okay, Corey?
Once the case management software is implemented, and do you think that'll help decrease the amount of arrears?
I don't know. I don't know that it necessarily will. I think that it will improve our ability to account for certain things within the program. But the arrears balance, again, the thing to remember is that the obligation to pay support is on the person who is the subject of the order or the agreement. And so the enrollment in maintenance enforcement is not a guarantee of collection. The big number files, the 300 files that we have, often I would suggest that on all of these files, our enforcement activities are maximized. Every single tool that we have to try and collect that money is in place. We've got federal interceptions. We've got, we're asking for information from health, from Access PEI, from social development and housing to try and get to see if there's anything new. Has this individual registered for employment? Have we located this individual who is what we call an absconding payor? And so I cannot sit here and say that even if we had every single tool conceivable, we cannot guarantee that we can collect these supports. I can sit here and tell you that maintenance enforcement does everything they can based on all of the information that they can, as we talked about earlier, some of which we cannot share, to maximize the support that is collected under an order. We are taking people to court. We are putting people in jail because they're not paying their child support. But the obligation to make that payment is on the person who is the subject of the order or the agreement. If they have a legal payment source and we find out about it, we can take steps to try and collect that. But the other reality is that, again, someone may choose not to file their tax returns because they know we have a federal interception in place, and they know that as soon as that refund hits, we're going to get it first and we're going to take it, right? So we do what we can, and sometimes we do it without notice, because if we provide notice, somebody's not going to, if they know we're going to garnish their bank account, they're not going to put the money in there. So I can sit here and tell you that the new CompuTrust maintenance enforcement system will absolutely assist the maintenance enforcement officers within our program in being more effective and more efficient at the work that they do. But I cannot tell you that it's a guarantee that there will be fewer arrears on files.
Okay, Corey?
In terms of arrears, so like as children get older and move out and become adults, work, and that person hasn't paid child support, and I know there's spousal support too. Does that come off of, after a number of years, does that come off the arrears total, or is that?
Not necessarily. So we have a policy through the program that, so what you're talking about is something that we call a terminating event. And so if someone is no longer eligible for child support, their order or agreement terminates. The arrears balance continues within our program if they continue to be enrolled in the program. And so as long as that arrears balance is there and people want to be involved in our program, we can have a file where the child of the program is now 44, and we are still actively trying to take steps to collect the money that is owed. We do have a policy that we do reach out to the parties to the program, and in this instance we mean the beneficiary. If the beneficiary advises us that they no longer wish us to attempt to collect the money, we would withdraw the order from the program, with the understanding that at any point that individual can re-enroll in our program. There may be a need to ask the court to clarify the arrears balance if there's some dispute, but if somebody wants us to continue collecting or attempting to collect arrears, we will happily do it. There's no statutory kind of dismissing of child support obligations. If you declare bankruptcy, still owe your child support. Still.
Corey?
And so is that number included in the 10.4?
Yes.
Okay, and how much, do you have an idea of how much of that would be?
I'm not certain that that's information I can get. I can certainly look into it about how much is on terminated files. Okay.
Corey?
I think Carla had mentioned it earlier, but when someone does call in and says, I haven't received my child support in 6 months, what can we do, or what's that process, or what?
So again, we are a neutral support agency, and so if somebody calls us and asks us for why they haven't received support, one, we can tell them in broad strokes that we have maximized collection, we have maximized enforcement on a file, but again, it's a little bit complicated, right? Because we can't, for example, tell them if we have personal information about the other party on the file, we can't disclose that information to the beneficiary, right? And so we can tell them that we have done everything that we can do on the file to collect enforcement, and as much as I acknowledge that this is challenging, we would advise them that we are not a guarantee of collection, that they can be confident that we're doing everything we can to collect that support, and we would talk to them about the types of enforcement tools that are available to us. So again, within the limitations of what we're permitted to disclose, but we can advise them that we have tools up to and including bringing people in front of a judge and asking to have them put in jail, right? Which for some people extremely motivating, for some people not motivating.
And although they may have reached out before then, they may have other tools, such as the Child Support Guidelines Office, or other tools to help the person who is calling with their file, that they can potentially go and get an update, or if they're concerned about something, there might be some other avenues that you can refer them to try to deal with their file, even if maintenance enforcement is kind of maxed out on what they can do.
Okay. Corey?
Just because I did have someone tell me that they said they felt like the onus was put on them to find out where he was working. Meanwhile, they're working 5 jobs just to try and pay the bills, and they're not receiving any child support.
We absolutely ask the beneficiary under an order if they have any information about the payor. Oftentimes, they're the best source of information that we have. We can send legal information demands to multiple places, but often the beneficiary under a support order has more information than we have available to us about the status of the person who's supposed to be paying them support. And so just because we have that conversation with a beneficiary under a support order, that's not at all indicative that that's the only thing that we are doing. Again, as I said earlier, we send information demands regularly to social development and housing, to health, to access PEI, to basically if we send them to banks on a regular basis trying to find out where people are banking. But it is absolutely one of the tools in our tool belt to ask the beneficiary what information they have, because they often know more than we do, because they know the person and they sometimes have a contact kind of sphere around that individual. And so it is absolutely one of the tools that we have, but it is absolutely not the only tool that we have.
Corey?
I know over the past, I guess since this audit was completed 5 years ago, there has been some changes made, and I think under the previous administration too, they had made some changes to do with, I think, the driver's license. So I think that was one of them, if I can remember correctly. But, like, would you say it's working? Like, do we need to do more? Or, because, like, obviously the numbers aren't really changing, I guess.
Again, I don't know if I agree with that statement about the numbers not changing. Again, there's so much movement.
That's what they do say. But.
Right, but again, those numbers the $10 million in arrears today may not necessarily be the same $10 million that was here 5 years ago, right? And are we seeing work that's being done and effective work that's being done on files? Absolutely. Again, we are bringing people to court. We are suspending driver's licenses. We are filing maintenance orders against land. Once again, we cannot guarantee collection. Whether or not there can be a separate discussion about individual social and moral responsibility to pay support towards children and spousal support, that is not what the maintenance enforcement program does. We are a neutral, order-based program that takes steps to maximize support that is dispersed and collected for support orders and agreements in PEI. And so whether or not, as a social discussion, there's more that can be done to help people to understand why their support obligations are important. But at the same time, again, we are a neutral program. There are two sides to every order, right? There are individuals who, for various reasons, have a change in circumstance, right? Who have to go to court and request that their order be changed. For every call that we get from a beneficiary saying, I haven't seen my support payment this month, we get a call from a payor who says, I was in a car accident, I've just lost my job, I had a family, I had to go out west for 3 months because my grandmother was in the hospital, right? We are obligated to take action against the order that is written. And so can we do more as a society about incentivizing the payment of child support? Absolutely. But through the maintenance enforcement program, we have a number of excellent tools. Again, we are constantly engaging in legislative review, in best practices with other jurisdictions. We are involved in a number of federal, provincial, territorial working groups that also look to other countries about what they are doing to maximize the collection and disbursement of support. So yes, absolutely. We continue to look to see if there are additional tools that we can add to our tool belt.
And as a department, there are policy personnel that aren't actively in the maintenance enforcement office that can do that type of work, so as not to take their people away from the enforcement matters, to update and try to look at innovative tools that might be available outside the jurisdiction that can be brought to our jurisdiction, as you say, to kind of add to the ability to deal with these issues.
Yeah, I guess just, and I know you do all you can to get the maximum payment possible, and I guess I just always have zero sympathy for payers that, they can find excuses, but unfortunately the necessities of life go on, and, kids can't just take a 3-month break from eating because, so anyways, that's just a comment I wanted to make.
Okay, thank you. Gord.
Yeah, thanks a lot. And as I'm sitting here, and you mentioned the social and moral aspects of it, we have sex registries in our country. Is there any ability or thought process to, after a certain point in time, that we have a registry? You can, is there a thought to that, or is that too far?
So can I just interrupt for 1 second? So it's not the merits of the policy, right, of the legislation. I'm going to leave it to you to answer that question, but I do know that it is outside the scope of the Auditor General, and remember, I just want to I'm giving lots of leeway, but to also keep it within the scope of the committee as well.
Sure,
So
yeah.
I'll leave it to you
I
if
just
you
have
want to
one
answer
question
that or
for
not.
Yeah.
We constantly engage in review of our obligations under the legislation, and, you know,
Yeah, perfect. Yeah, good answer. Yeah, it just came to my, after I was listening to various questions, I just wanted to, I couldn't get the question out of my head, so. And the other thing is, you have a great section here. Like, this is a tough morning to talk about, and when people are splitting up and families are splitting up, there's sometimes violence on the way out, and we got done Family Violence Prevention Week last week, and I know it'd be tough for a lot of you to see that. Do you want to just talk about I saw some stuff in your questions. You had it on a prominent page, and do you want to talk about how you deal with somebody or that comes to you, a payee, or if they've been in a violent situation? How do you approach that as a section?
so on our enrollment documentation, we have the opportunity for individuals to flag whether or not there may have been domestic violence in the relationship. If they choose to flag that, that's noted on their file, and in the event that we would need, for example, to meet with that individual, we would be aware that a meeting, for example, would not be set at the same time with the other party on the file. You would have noted that throughout our discussion this morning, I've made reference to our obligation to protect personal information. One of the reasons that we do that is to ensure that we're not inadvertently disclosing contact information or locations of individuals who do not want the other party on the file to know where they or their children are. And that is why, as both in our policies and in our practice, we are very careful about the balance that we have to play between disclosing information that is required from one party to another. For example, there are individuals within our program who have experienced family violence, who do not want the payor on the file to know where the child is if they're enrolled in post-secondary education. We do not disclose that information without the consent of the parties. And so we are very cognizant, and you are absolutely correct that breakdowns in families can be extremely challenging, high conflict times, and we at all times are cognizant of that, understanding that our role continues to have to be neutral.
Neutral, yeah, absolutely. Great, thank you.
We're good? Okay, Carla?
There comes a point in time in every meeting where I just feel this need to say something, and hearing every time, I'm sorry, this is quick, but kind of to further a bit of what everyone's been saying, but this is kind of just yet another complex layer, and not this. I know this is out of your scope in terms of what your program can do, because it's a neutral thing, but another complex layer of what we need to do as a province to better support and nurture the health and development of our children. And that's all I have to say about that. Well, I have lots more to say about that, but I'll leave it there.
All right, thanks, Carla. So I think we've come pretty much to the end of our questions. I just wanted to quickly ask one or two myself. So in the report, it had identified that there was 4 enforcement officers at the time of the report. You had mentioned adding one more. Does that mean we have 5 enforcement officers now?
We actually have 6,
We have
because we
6,
took an
okay.
existing position that was vacated,
Okay.
because we had a staff person who was the successful candidate in the competition for our new enforcement officer position. We took that old position and reprofiled it into an additional enforcement officer position. So.
Okay. So was that, I'm just gonna, you had an intake officer, a bookkeeper, senior enforcement officer, sorry, and then four enforcement officers. Which one?
So the bookkeeper enforcement officer position was vacated, and we reprofiled that into an enforcement officer position, and then took the bookkeeping duties and transferred it into the intake officer position.
Okay, all right, thank you for that. And sorry, I've got a lot of papers around. So I was told a story of a constituent who went through the process, did the intake, and actually had a really, really positive experience. Within a month, the person's, the payer's wages had been garnished. And so it was actually a very quick process for that person. I don't often hear that, and I know it's often that you hear negative stories versus positive stories, so I wanted to share that with you. And when I talked through that with the person, one of the questions that they had actually asked to maintenance enforcement when they were going through the process was, first of all, they were surprised that they had gotten through, it had processed so quickly. But the person on the other end of the line, and this was a number of years ago, like 10 years ago, so I don't know if it was you, but they had mentioned that it was the director that was actually processing the files. Mm-hmm. And the director at that time had said that every 10th file, the director is the one who's processing the file. Is that still the case, that the director takes every so often a file?
Right. So just to be clear, I am not the Director of Maintenance Enforcement.
Oh, okay. I'm
So
sorry.
the Director of Maintenance Enforcement is a employee within the Maintenance Enforcement section.
Okay.
A little bit challenging because of the duplicate terminology, but I'm the Director of Family Law and Court Services. And so I'm the senior manager in the section of the department. Mm-hmm. The Director of Maintenance Enforcement is a statutory appointment, and that individual, yes, does take files. Okay. We have presently just reevaluated as part of our ongoing review how files are assigned. Okay. And so I wouldn't be able to tell you off the top of my head where we landed on that in discussions with the staff. Mm-hmm. But I can tell you that the director does carry an active file load.
Okay. And one of the things that director did immediately for this case that I'm speaking of was garnish the wages. So in the Auditor General report, it says, for example, this was when they were talking about inconsistencies in enforcement procedures, and it said, based on the AG's interviews, we noted that 2 enforcement officers do not use bank garnishments as regular enforcement activity. As a result, certain enforcement officers may have a better chance of collecting arrears balances for the beneficiaries than others. Can you tell me if that's still the case, if those 2 officers at the time who did not actively use bank garnishments have changed that practice?
So if you were to take the opportunity to look at our updated policy manual, yeah. The director now has a policy that we are maximizing all enforcement options that are available. Again, sometimes the decision to take to exercise the discretion to engage in an enforcement activity is really file specific. And so it may not be the case that every single file in the maintenance enforcement program would benefit from a bank garnishment.
Right, but can I just interrupt for a second? So in that interview, the 2 enforcement officers stated that they do not use bank garnishments, not just once in a while they don't use it. It was stated to the AG that they do not use bank garnishments.
Right.
So that would be a tool in the toolkit that's not being used. So I'm just asking, has that changed?
Yes, okay. And I only point out that it may not be the case that should every file now be pulled, it may not be the case that there's a bank garnishment on every file. Yeah. That was the only correction I was attempting to make.
Okay.
So it is absolutely the policy now that every single tool that is available is considered by all of the enforcement officers.
Perfect, thank you. And then just 2 quick housekeeping. So is there performance-based measurements on the checklist, for instance? So you have now a checklist that goes into every file stating what the decisions were and where it is. Do you have any mechanisms in place to ensure that that is being completed? Because it sounds to me everything's pretty manual right now. You actually go to a file room, take a file out, which surprises me in 2020 that we're still talking about not having electronic filing systems within our government. But anyway, I digress, and I'll have to deal with that somewhere else. But anyway, so is there a report measurement, like a measurement where somebody would do spot checks on that?
So as, again, if you were to refer to our new policy manual, the director engages in random file audits of each of the enforcement officers. And I can also tell you that they meet on a weekly basis, the maintenance enforcement staff, and the director is reviewing all of the arrears balances for each of the enforcement officers and engaging in a discussion about what opportunities there may be for additional enforcement or what opportunities there may be to assist with enforcement. And so there is ongoing review.
Because as part of that process, one enforcement officer could have a very difficult file, and sometimes
Yeah.
it's good to share with your colleagues. They may have some better practices, and then they can action it.
Absolutely. Okay, last question I have. The deterrent fee, that you had mentioned that it was in the regulations. Can you tell me where in the public accounts that is actually captured? So is it under Department of Justice or is it under Treasury Board?
It would be under the Department of Justice. It would be listed in the revenue from JPS.
Okay. So that's all my questions. Does anybody else have any questions? So I know we've almost gone 2 hours. It's hard to believe how quickly time can go in this room. But on behalf of the committee, I'd just like to thank you very much for your very extensive, clear answers. And I look forward to, well, I'll put out to the committee at the end of 2020, you hope to have the software program implemented. Would it be the desire of the committee to say we'd like to see an update towards the end of 2020 to see where that stands, to ensure that that's still on track? Is that how we'd like to handle this? Okay. Anything else that we'd like to see before we say thank you? And any other updates? Okay, so an action would be an update on the implementation of the software towards the end of the year to let us know where that is and whether it's on track, delayed. So hopefully well ahead of schedule. So again, thank you very much. And we're going to take 2 minutes and then we'll come back just to talk about the final items on the agenda. Okay? All right, so next on the agenda is to I have to keep flipping, review correspondence. So we had asked, after we met with Access PEI and the management of contaminated sites audits, we had asked for them to provide us updates. So we received 2 letters, one from Brad Colwell. No?
Sent to.
Oh, those are sent too.
Yeah.
So we don't have any oh, thank you. So we've sent them follow-up letters. Sorry, I misunderstood that. I should know when it says the Legislative Assembly. Yeah, so they have to respond to us on an update of where they are after we did our follow-up with them. And I believe that was in October that we met with them. So those were 2 letters that were sent out. Sorry about that. Did anybody else receive any correspondence from anybody? Okay, so review of scheduling. I'm going to let you go with that.
Okay. The next scheduled meeting is March 10th, when IRAC will appear to discuss petroleum product pricing. After that, there's March 31st, I have a confirmed date for personnel from finance to appear to discuss property taxes and corporate taxation. I've provided some dates for IIDI to appear, but they haven't gotten back to me yet. What else? The committee had asked about a briefing on the 2018 Auditor General's report. The Auditor General's office is completely occupied with preparation of the 2020 report right now, so they will not be able to provide that 2018 briefing before the sitting of the legislature, but subsequent to that, perhaps the new Auditor General could do so with the staff of the office as well. The Auditor General, the 2020 report is expected on March 15th. She would be available to the committee for a briefing on that on March 24th if the committee wants that to happen.
I'm assuming yes? Yep, everybody's nodding, so we'll ask the AG to come in for March 24th. That's great.
I think that covers it.
Covers it, okay. So, any new business? All right, without further ado, I will adjourn. Thanks, everyone.